versus Jessica Marie Wellington.
Your Honor, if I may go in the attorney room and grab my notes.
Yes.
Thank you.
All right, counsel, these are case numbers 26306 SM. In that file, we're here for a probation violation hearing. Was it a hearing or?
Yeah.
Yeah, okay.
And I believe she entered.
I thought she did too, yeah. So it's
Yeah.
set for sentencing.
Yes, Your Honor.
And then the other file, case number 26818 SD, we're set for sentencing in that one as well, to a plea taken to a high BAC back on April 23rd. The court had set these over, so I had time to review the substance use assessment. Appearances, counsel?
Lisa Dahl for the people.
Thank you, Your Honor. Taylor and Ann Prevent on behalf of Ms. Wellington.
All right, counsel, are there any, have you both received the recommendation from the probation department and the substance use assessment?
Yes, Your Honor.
Yes.
Are there any corrections to be made to either? Mrs.
Not from me.
Fiorvento?
Nothing further, Your Honor. We are ready to go forward. We had planned to sentence last week, but there was an issue with, I believe it was the JIS system.
No, the issue last week was I hadn't received the substance use assessment in time to review it and consider it to sentence that day.
I'm sorry. I meant we were running behind. We didn't have the time. I'm sorry. I'm very sorry there.
All right. And when I asked about the probation report, there was an amended one filed today. Did you both receive that?
I do not have an amended report from today.
I did see it, Your Honor.
All right. I guess it was filed yesterday. Today's the 30th, so it was filed yesterday.
I just may have a quick moment to review.
Sure.
Thank you, Your Honor. I reviewed that with my client. No, we're good to proceed.
All right, allocution then?
Thank you, Your Honor. We would respectfully request no additional jail, but if the court does feel that is necessary, oh, I'm sorry, I do need to also put a few, make sure I'm not missing any records. No corrections, comments, additions to the substance use assessment. Thank you. We would respectfully request no additional jail, or we would ask that the court follow the recommendation of only 15 days minus the credit. While this violation did occur very quickly after Ms. Wellington was first put on probation, since that time, she has done very well out on bond. She has not had any other issues that I am aware of. Also, Ms. Bismack has confirmed that she's taken steps to work with CHS. She's worked on her community service and completed about 4.5 hours so far. She is showing progress. She is making steps. Yes, we had a hiccup initially. We're not denying that that occurred at all, but we are asking that the court look at her actions since then to show she is making effort, she is supervisable, and she is prepared she would respectfully request that the court give her another chance to continue to show that to the court. We've had a lot of delays in this matter, and we understand she's used that time though very efficiently to prove her willingness to comply and move forward and reform. Thank you.
Thank you. Ms. Dole?
Thank you, Your Honor. I do ask the court to keep her on probation or place her on probation in the new case and keep her on probation on the other case. With regards to the OWI case, I believe 2 years probation is appropriate. The blood alcohol level was extremely high in this case, and she was on probation when it happened. It seems like she has a serious substance use disorder. The substance use assessment stated that she was at the severe level. So I believe that a long term of probation would help make sure that she stays on track. It sounds like she started Catholic Human Services. I believe a longer probation period would ensure that she does get the rehabilitation that she obviously needs. And the reason I asked for probation in the other case to remain is there are other terms of probation that I think would benefit her in a different way. There's community service that was ordered in that case. There's also no contact orders in that case that I would ask the court to keep in place, and that's why we're asking for probation to remain. This is her first probation violation, although it's a very serious violation for committing a new offense, but she is getting sentenced in that case as well to other terms. So I asked her to remain on probation in both cases. I think it'll benefit her. There are different terms in the first probation case that I think should remain, specifically the no contact order. I believe minimal jail time is appropriate in this case. She does have some treatment that she started. I think it'll benefit her to continue that treatment. I don't believe a significant amount of jail time would benefit her as she's already started treatment and working on it. So that is the request of the people. And I do want reimbursement to prosecutor's office for the OWI and also to MSP for the blood draw. I'm asking for $100. Thank you.
100 for each.
Yes, Your Honor.
Ms. Fiorvento, I don't know if you've had the opportunity to discuss what my next question is going to be with your client, but does she wish to continue to be on probation in the trespass file?
We didn't speak specifically to the trespass file. We spoke more in general terms. Her goal would be probation over jail, if I may consult with her briefly.
You may.
She would like to continue probation in both files, if that is what the court is, if the court is inclined to do so.
Okay. All right. Ms. Wellington, you had the right to address the court prior to sentencing on either file. Is there anything you'd like me to know?
Yes. I do have a serious alcohol problem. I was in a very bad dark spot at the time of this OWI. No excuse. I'm working towards recovery, staying sober. AA classes, I've retained employment that I'm waiting to start, community service, working with the fire chief, helping out at the fair, clean up graveyards, etc. I want to stay on my path to recovery. I would like to stay out of jail, obviously, and continue my classes and my counseling and all the positive things that I'm doing to stay sober.
Okay. So going through the assessment, I can see you've had some substance issues in your past. The assessment says that in 2010, it looks like you were in a residential treatment. Am I reading that correctly, though, that you left before you completed treatment?
That was, yes, and it wasn't anything court ordered. I was pregnant at the time.
Okay. So have you done any, other than that, have you done any type of formal rehab programs?
Yes,
All right, what have you done?
I've done like, and when I was in Ohio at the Suboxone clinic, which I'm not a fan of Suboxone,
Mhm.
but I was on that and I was successful throughout.
Okay.
And until I moved up here.
But drugs aren't an issue for you up here, correct? It's the alcohol.
Correct.
Did you swap one substance for another?
Yes, I did, Your Honor.
So the treatment that you did back in 2010, was that for controlled substances then?
Yes,
All right. And how long have you been going to AA?
since I actually started before I got this charge, OWI charge, I started going to Lighthouse and now I'm going more to more meetings. At least 2-3 times a week.
Okay. Are you doing in person or by Zoom? Okay.
Zoom right now, and then I have in-person scheduled coming up.
So what was going on this day? I mean, to get to a, what were you, at 308, if I remember? Yeah, 0.308.
So, my ex, we were together about 20 years. He left me for another woman. I went downhill.
Is that the house that's the subject of the
Correct.
trespass? Okay.
Got me nowhere, as you can see. I have a 14-year-old daughter I have to take care of at home. And things are better now. I mean, obviously, I'm not drinking and I don't plan on drinking ever again. I know this will be a continued recovery process even after all this, right, for the rest of my life.
Anything else you want me to know or consider?
I think that's all, Your Honor.
So what I struggle with is there's two things I struggle with. One is probation for somebody who's already violated probation. We're here for a probation violation. And the other thing, the other issue I struggle with is two probations. That to me seems like overkill. And I understand why the people are asking for it, because there's a no contact order in place. But there's other avenues that can be taken for those persons to protect themselves. Because really there's nothing in the current standing probation order other than the no contact that I could not order probation if I go that route in the new file. The old file, 306, was counseling pursuant to the probation officer, no contact, and any additional programming along with community service work. Other than the no contact, that's all things I can order in the new file. And if I'm doing my math correctly, that no contact order would run out in August. So there's only about 3 months left of it anyways. But I also have somebody who was on probation who now, just 2 months later, almost 2 months, looks like you were placed on probation back on February 25th and on March 9th. So yeah, not even 2 months. Just a few days later, you're picking up this new charge and you're a 0.308. But it's also not lost on the court that I've not had any violations with you since being on bond, and I placed you on bond back on March 10th. So the sentence in 306 is going to be to terminate probation. I don't find it advantageous to continue on probation. The court does have it in its authority to terminate probation because the alleged violation is, I shouldn't say the alleged violation, the violation, convicted violation now is new criminal behavior that does allow the court the authority to terminate probation. So I'm going to terminate unsuccessfully. Can you find the probation order? Where is that sentence? Then I get to case number 26818 SD. I am going to put you on a period of probation for 24 months. During that time, and I believe that is appropriate, given that you were on probation at the time of the violation and that you were a 0.308. And also given that you test positive for having a severe substance use disorder, along with your prior history with substances. So I believe 24 months is appropriate. During that time, you're not to violate any law. Report is ordered, not leave the state without the consent of your probation officer. Keep your contact and employment information current. By law, you are eligible for early release. So if you do everything we ask you to do at the 24 month, you could be released from probation. I want you to attend the alcohol highway safety education class and the victim impact panel. No alcohol, no illegal controlled substances, and no recreational marijuana. You will be subject to random testing for the illegal substances, and I want you on daily testing for another 60 days. You are to follow the substance use recommendations, substance use assessment recommendations, counseling for drug and alcohol. I want you to attend the EOP, which is extensive outpatient programming. Any counseling your probation officer feels is appropriate. And any additional programming she feels is appropriate. I normally don't do this, but well, no, I'm not gonna do it. All right. And then that leaves us what to do with jail. By all purposes, you've earned a jail sentence out of this. Your only saving grace is how you've acted between on bond. So I'm not going to order a jail sentence today.
Thank you, Your Honor.
There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee. You pled to a high BAC, so there's a $200 fine, $150 court costs, $150 attorney fee. I find that those fines and costs are appropriate. The first two, the crime victims' rights fee and state minimum fee, are required. I find that given that the defendant was on probation at the time, we went through final pretrial and we're back here for sentencing and was on a violation. I believe the court costs, fines, and attorney fees are also appropriate. The probation fee, I'm only going to charge you for the 12 months. That's $360. If you end up staying longer than the 12 months, you're going to be required to repay the monthly probation fee of $30 a month.
I understand.
There is a $100 prosecutor fee and $100 to the Michigan State Police. That is reimbursements for, which is allowed pursuant to statute, reimbursements for a portion of their costs in prosecuting drunk driving cases. There is 1 day jail with 1 day credit. Because you sat 1 day, you are entitled to $5 back towards your fines and costs. Counsel, have I missed anything in a judgment of sentence?
Will you be doing any community service?
Oh, yes.
Last case.
Thank you. Thank you for that. So in the last case, I had ordered, I believe it was, let me just double check, 30 hours of community service. I'm going to increase that to 60 hours of community service. Anything else, Ms. Dolan?
No, Your Honor.
Ms. Firavento?
No, Your Honor. Thank you.
All right, Ms. Wellington, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. I will waive that while on probation. Do you have any questions for me?
I do not, Your Honor.
All right, you can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan, and then you'll need to go downstairs to probation and get signed up for probation in the new file. Ms. Bismack, is there anything I've missed or anything you want to address on the record?
No, Your Honor.
All
Thank
right.
you.
Thank you.
Wellington faced sentencing on 2 files, a prior trespass case, 26306 SM, and a new high BAC OAA charge, 26818 SD, which she committed just 2 weeks after being placed on probation with a BAC of 0.308. She was rated at a severe substance use disorder level. Her 20-year relationship had ended, triggering her downward spiral. Since being placed on bond, she had shown strong compliance. The judge terminated probation on the trespass file and sentenced her to 24 months probation on the OOI, with daily testing for 60 days, EOP programming, counseling, 60 hours community service, and extensive fines. No jail was ordered due to her good conduct on bond.